Okay, we're definitely getting through co-tenancies. Hopefully, landlord-tenant. Chapter 6, ownership and marital interests. Co-tenancy and co-ownership means that greater than one person have concurrent rights of present and future possession of an entire property, as opposed to consecutive rights of possession, as in the present and future interests we just discussed. Examples of co-ownership include partnerships or marriages can have unified treatment. Common law, concurrent interests, types, characteristics, and creation. 1. Coparceny. The eldest son is heir. If no son, then tenants in common among daughters. Partnership, tenancy in common, favored over joint tenancy, descendable by will, transferable by any tenant in common, that tenant in common interest by deed. Each co-tenant has separate but undivided interest in the property. At common law, the tenant in common could not have unequal shares. Modern law allows unequal shares among tenants in common. No right of survivorship. Joint tenancy. Per my A per two. Right of survivorship. That's French. All of these real property laws are in like French. Per my tout. Per my and per tout. That means by the half and by the whole. I like it. I like it. Now, right of survivorship, 4 unities. What are they? Time, title, possession, interest. Is there a mnemonic to remember them? Oh yeah, they're all T's, kind of. Time, title, interest, and which they go and possession. Because they're not all T's, but whatever. In California, they only require possession, unity, and equal shares. Time, the vest at the same time. Basically, the interest among the tenants must vest at the same time. Title must be granted in the same instrument. Interest affording identical interests and of equal duration. And possession gives all tenants in common the right to possession of the whole property. And California requires possession, unity, and equal shares. So, interesting they say equal shares here because they were saying earlier that per common law, the tenants in common could not have unequal shares. So here, California requires equal shares. So they're kind of going back to the common law. So anyway, now we're talking transferable during life, but severs the joint tenancy into a tenancy in common. If there's a transfer, requires the joint tenancy requires clear intent to create a joint tenancy. Jurisdictional differences. A and B as joint tenants with right of survivorship and not as tenants in common. A and B as joint tenants with right of survivorship and A and B as joint tenants is sufficient in California to create a joint tenancy. Tenancy by the entirety, 4 unities required, again, time, title, interest, and possession. And also requires marriage is like the 5th unity and for right of survivorship. It's pretty much the same as joint tenancy. It's just that Marriage is another required unity, and it doesn't really talk about just how you would destroy this type of an interest. You really can't transfer it without the other spouse. Whereas in a joint tenancy, you can transfer it. Presumption, tenant, and maybe that's not everywhere anymore, but you saw the case about, I don't know if it'll come up, the case about the secret transfer, the straw man, and how Barbara was saying it's not requirement anymore. Basically defeated by that case. So let's see if we get to it. Presumption, the tenancy in common is preferred over the joint tenancy. The joint tenancy must be created with technical language expressing the intent to be a joint tenancy. Probate avoidance, judicial supervision of administration of decedent property that passes to others after death, i.e. probate, is avoided by the courts. Tax reduction preference, have the tax paid spouse's death in tenancy in the entirety. Creators must be wary of joint tenancy and attached property before death of tenant or their interest disappears into cotent. So I think these are misspellings. I think I meant to say creditors, not creators. And must be aware of the joint tenant and attached property before the death of the tenant or their interest disappears into cotent. I don't know what I meant by that either. But anyway, severance of joint tenancy by intent, for example, by living trust. Simultaneous death follows a half and half approach. And if one joint tenancy kills the other, he forfeits his right to survivorship. Slayer statute. There's another word for it, but whatever. Criticism against not recording severances of joint tenancy. Title theory and lien theory of mortgages impact joint tenancy, severance, or may consider intent. So my outline, reference case number 40 of the book Harms vs. Sprang from 1984. The joint tenancy was not severed by mortgage, and the whole interest in property passed to the surviving joint tenant with no encumbrance from the deceased joint tenant. So it wasn't severed by the mortgage. Right of survivorship defeated the encumbrance of the decedent joint tenant. A mortgage will not sever. So in that case was in a lien theory state or jurisdiction, because in that case, the mortgage did not sever the joint tenancy. However, in a title theory state and jurisdiction, the mortgage will sever a joint tenancy. Multiple party bank accounts, joint account, true joint tenancy, and taught in trust, savings account trust, payable on death, right of survivorship, testamentary instrument without seal. Savings account trust, POA, to provide for someone's expenses during his life and then go to heirs. My favorite part is about the bank accounts. Banking case issues. Of course, I took all the notes in the world. BOP is, okay, the burden of proof is clear and convincing evidence of intent. Cases regarding equal shares, fractional shares, and traceable shares is estate of Shia, Wright versus Bloom, These are New England case, which means it's probably old. Franklin versus Anna, National Bank of Anna, another New England case. Newton County versus Davison, Allen versus Gordon, Malloy versus Stuttgart Memorial Hospital, and Uniform Probate Code Section 6 through 211. Now, all these cases are like giving the directional citation: northeast, northeast, southwest, south, southwest. So they're probably, they don't know what they are. I don't know the dates on any of them, or what the states that they occur in, but I feel like they're probably in the federal circuits. I don't know. Maybe I'm just crazy. Relations among concurrent owner. Neither a joint tenant, not a tenant in common, can do any act to the prejudice of his co-tenants in conflict of their reciprocal rights. Communal ownership encourages inefficient use. All right. Partition. So we're getting to the part where like there's some bad blood. Voluntary termination of co-tenancy or recourse to the equitable action of partition is necessary. Case number 41, Delphina versus Cotenancies of 1980. Partition in kind is given preference in this case, and partition by sale is a last resort if partition in kind is impractical as a factual matter. Physical attributes of the land are such that partition is impractical or inequitable, and the interests of the owners would be better promoted by a partition by sale. So this is kind of important. Party favoring partition by sale bears the burden to show no less restrictive way. Partition in kind, impractical and equitable due to physical attributes. The interests of the owners would be better served by partition by sale. I just kind of like re-highlighted those things. And the economic value is relevant but not dispositive to the court deciding this case. The Uniform Partition of Heirs Property Act is cited here for remedies, for example, notice. And, just going back to this Delphina case, they're really pulling for a partition in kind because of the design of the land. I feel like part of it was a dump. That literally. And like at the end of like a neighborhood, and there was maybe a neighborhood lot also aligned to it, and the tenant that was running the dump wanted to keep it, and I guess it was for turning a profit, and the other tenants were like, no, we want to sell it and get our money, and we're going to get more money if we sell it than if we let you have that part that's more profitable. So something like that is what happened. So what was the outcome? And where does it apply today? Well, you can argue it to death, so it almost doesn't matter what the outcome is. But just know the way to argue it is that the physical attributes, is that the court is going to prefer a partition in kind over than forcing a sale and favor that. And thus the party that wants the sale bears the burden to show that there's no less restrictive way for like a fair result. And if there is no less restrictive way, and or the partition in kind would be impractical, inequitable due to the physical attributes of the property, then the court may choose that the interests of the owners would be better served by the partition by sale, but the economic value while relevant, is not dispositive in that inquiry. Spiller versus Macureth. Ouster between co-tenants was not sufficiently demonstrated. Rule: in absence of an agreement to pay rent or an ouster of a co-tenant in possession is not liable to his co-tenants for the value of his use and occupation of the property. It's going to be a long freaking recording. Rule 1, co-tenant using property is not liable to the other co-tenants for rent unless there is a showing of ouster. 1, adverse possession. 2, title denied. And these are the elements of ouster. There's adverse possession, the title is denied, and out of possession, co-tenant must show she asked to enter and was refused. Ouster is used to describe two distinct fact situations. 1, the beginning of the running of the statute of limitations for adverse possession and liability of the occupying tenant for rent to other co-tenants. Case number 43, Schwartzbaugh versus Sampson, 1936. The lease was created by one joint tenant for part of an orchard to be used as a boxing ring against the co-tenant's will, and this was dismissed by the trial court and affirmed by the appellate court. Well, what was? Right? Probably the tenant brought an action to invalidate the lease by the joint tenant. And this is a California case. Rule: the act of one joint tenant without express or implied authorization or consent from his co-tenant cannot bind or prejudicially affect the rights of the latter. That would be the general rule. But in practice, can only lease the right of possession which the lessor already has. The joint tenant not joining in the lease is not bound by its terms, and that she can recover from the tenant, his co-tenant, the reasonable value of the use and enjoyment of her share of the estate if the tenant under the lease refuses her the right to enjoy her moiety of estate. I remember she was in the hospital when the joint tenant wrote this lease, and there's a bunch more rules here. Rule: the lessee of one co-tenant holds the possession of his lessor, and that a co-tenant in possession hold for the other co-tenant, and not adversely. Ouster is only way to threaten title. Rule: lessee in possession of real property under a lease cannot despite his landlord's title, nor can he hold adversely to him while holding under a lease. Rule: one of two or more joint tenants cannot, by making a lease of the whole, vest in the lessee then his own share, since that is all to which he has an exclusive right, since a lease is, however, valid as to his share. I have literally no idea what the outcome of this case is. So you hear a bunch of rules. And a lot of them don't really answer the question directly. The question is the lease valid? Does there need to be an ouster? That's all I want to know. I don't know. Holding: lease by co-tenant 1 to co-tenant 2 is not null, but valid contract, giving co-tenant 2 the same right to possession of the leased property that co-tenant 1 had. But they had I remember with tenants in common or joint tenants, I remember that the unity of time, title, possession, and instrument. In possession, this isn't equal shares. And that what they mean is that both tenants can have everything. I mean, they don't own it all. They own it half. They own equal shares, like half and half, but they have a possessory right in the whole. So if one rents part, possession, interest, title, and time. Possession gives all tenants in common right to possession of the whole property. This case always messed me up because how can co-tenant 1 give his half without giving possession to the entire property? Because that's what he possesses. That's his interest. So the holding again is the lease by co-tenant 1 to co-tenant 2 is not null, but valid contract, giving co-tenant 2 the same right to possession of the leased property that co-tenant 1 had. So co-tenant 1 shares possession equally with joint tenant 2. And I mean, I remember the outcome of the case because there was a close-up that said that, like, the joint tenant, when she eventually got out of the hospital and she fought this case, and later on they actually liked having the boxing rink there or whatever, and that was great. So the boxing rink stayed. So what they're saying ultimately from all of these rules that don't make any sense is that, you know, they don't need the authority and the consent from the co-tenant to bind the property by leasehold estate, granting a leasehold estate. Sharing the benefits and burdens of co-ownership, Spiller versus Makareth, ouster elements are defined. Asserting one tenant asserts complete ownership, adverse possession, or denies entry to other co-owner, liability for rent to the co-tenant. So, that was another thing that I was interested about. So, the boxing rink rent, what's the outcome on that? Like, is it split among the two joint tenants, or because it's quote only, it's the same right? They co-tenant 1 gave co-tenant 2 the right to possession. That would be somehow only entitle co-tenant 1 to rent and not the other joint tenant, because I just don't think that's right. I think that the rent would go to both joint tenants because, as we were saying, with possession is that they have equal possession to possess the entire property. Their interest is in equal shares, but their possession is to the whole. So if you give any part of the whole to another, I feel like you do the rent to your joint tenant. So that's my analysis. I don't know what's written here, and I didn't understand it at the time. And now Spiller versus McElrath says that there's a liability for rent to co-tenant. Adverse possession is the third element of ouster. Adverse possession is extremely rare to divest a co-tenant because it will require unequivocal and notorious elements. Notes: accounting for benefits, recovering costs, action of partition by sale, partition in kind, action for accounting to pay rents, royalties, and other proceeds in excess of his share amount of receipts, not fair market value. In absence of an agreement between the co-tenants, the default rule is that income by co-tenant use of the property is not shared, whereas income from a third party is shared. All right, that makes more sense. some of the stuff, and I say some of it, I mean, this is all relevant. It's going to be on the bar. Action for contribution from the other co-tenants to reimburse one co-tenant for pay greater than his share of taxes, mortgage payments, other necessary carrying charges. Rule: American law, property, blah, super section 6.17 is that the protection of the interest of each co-tenant from extinction by a tax or foreclosure sale imposes on each the duty to contribute to the extent of his proportionate share the money required to make such payments. If the tenant who has paid taxes or interest has been in sole possession of the property and the value of the use and enjoyment which he has had equals or exceeds such payment, no action in any form for contribution will lie against the others. Yeah, you get a contribution for paying taxes, association fees. And on threat of extinction, the tenant who ponies up can sue the others for contribution. Right to contribution for reasonable repairs and improvement. The accounting is owable to improve in the amount of the increase in value, and in action for order of payment is called owalty. Majority rule. Necessary repairs are not subject to contribution by non-repairing co-tenants. And minority rule allows contribution if notice provided before repairs are done. So that's your majority and minority rules. All right. The regular rule is necessary repairs are subject to contribution. But here it says not. But this is my own outline, and I think I'm wrong in this one. And I think I remember Barbie right that contributions required for necessary repairs, but for improvements, it says here the amount of the increase in the value, and an action for the order of payment is called owalty, whatever. Improvements increase value beyond their cost, the improver gets the full value, or if the lesser of increase in value or cost or the greater in value is divided equally. However, the downside is borne 100% by the improver if cost of improvement exceeds the increase in value. This is the last part, leasehold, the law of landlord and tenant. The last part as far as I care. Yeah. The leasehold estate, aka non-freehold estates, include term of years, periodic tenancy, tenancy at will, tenancy at sufferance. I feel like I know these in and out. Term of years is a possessory estate that once created lasts for some fixed period of time, or for a period computable by a formula that results in fixing calendar days for beginning and ending. Durationally limited in some jurisdictions, fixed period or terminable earlier upon event condition happening. Example, death of landlord is irrelevant. Periodic tenancy, lease for some fixed duration that continues for succeeding periods, auto-extended until either the landlord or tenant gives notice of termination, i.e. from month to month. Month to month ends on the last day of the month of the year. They made such a big deal about this, and I feel like it wasn't on the bar. But it's like 1/1/20 to 1/31/20. Last day of the month, last day of the year. To be from year to year. Common law, 6-month notice required to end a 4-year, 2-year periodic lease, otherwise held over another term. For less than 1-year periodic leases, notice to terminate is length of duration not to exceed 6 months. Death of landlord is irrelevant again. Tenancy at will, tenancy of no fixed period, enduring for as long as both parties desire, at will or at death if explicitly expressed. Terminal by either party between payments, i.e. 30 days. Tenancy at sufferance, when tenant remains in possession after termination of tenancy. Eviction consent, which can be expressed or implied by accepting money for next period, which would create a periodic term leases. Case Garner versus Garish, Court of Appeal of New York, 1984. Held express intent was for only the tenant to terminate at will and was not extended to the landlord. Rule of law: a lease for so long as the lessee shall please is said to be a lease at will of both the lessor and lessee. That's the common law. The rule of law from the restatement is the landlord lease a farm to tenant for as long as tenant desires to stay on the land. The lease creates a determinable life estate in tenant, terminable at tenant's will or on his death. Holding: the lease expressly and unambiguously grants to the tenant the right to terminate and does not reserve to the landlord a similar right, which was the intent. And that's valid, according to Barbary. If you want the landlord to have the same intent, you have to say it, I think, is how that works. Selection of tenants, herein of unlawful DISC. 1968, FHA imposed most significant restriction on discrimination. Exceptions: Title 42 of the United States Code, I think, Section 3601, 3619, 3631 applies if greater than 3 single-family home rented at one time or 1 to 4 family dwelling that is not owner-occupied. Mrs. Murphy's boarding house, for example, without a realtor, without advertisement. That's not without. Meaning that Miss Murphy, advertised a property, you can't have your kids live here or something like that. And that was okay because she's a living landlord, or she only owned less than a quadplex. So she's allowed to be specific in her marketing like that, targeted in such a way that it does have it is exclusive. But it's only her. It's not like you do that at an apartment complex. Prohibitions 3604 apply to all without respect to the exceptions clause. And it includes advertising, renting, selling, refusing, and denial on the basis of race, color, religion, sex, added 1974, familial status, added 1988, national origin, and then it says handicap, added in 1988, found by not being modified to needs if reasonable, and 2 rules of construction is 1, accessibility, and 2, adaptive design. Subject to injunctive, declaratory relief, and punitive damages. See Shelley versus Kramer, and I didn't brief that case. I went right into the Community Reinvestment Act. No, the Civil Rights Act of 1866, and this is in Title 42 of the United States Code again. Section 1982, all citizens of the U.S. shall have the same rights in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, convey real or personal property. Prima facie burden of proof, the motive is irrelevant. Establish disparate treatment, impact, treatment, and causation. Matched pair testing to identify rental prevalence. Defendant then must establish governmental purposes justification. Examples, enter notes from book page 476. Remedy, subject to injunctive - declaratory relief and punitive damages. Legal fees are paid by losing landlord, and government tenants pay if suit was frivolous or in bad faith. Delivery of possession. Holdover tenant. Case, Hannon v. Dash, 1930. American rule concerning holdover tenant preferred on the basis of knowledge of the identity of the adverse possessor. Rules of law. English rule implies a covenant requiring the lessor to put the lessee in possession compared to American rule, which recognizes a lessee's legal right to possession but implies no such duty upon the lessor as against wrongdoers. American law of property, prospective tenant doesn't have to pay rent if he has no possession. I mean, these are important distinctions. What applies in America right now, according to Barbary, is what you would expect. So your landlord has to make your property available. Uniform Residential Landlord and Tenant Act. Prospective tenant sues holdover tenant for damages in possession. So that's according to that law, act. Sublease and assignments. Oh, my favorite. I actually probably wrote in the cases here. Yes, Slavin versus Rent Control Board of Brookline. Dumpster's case. I don't know. Landlocked land without ingress and egress. What is that doing there? Landlord rents to two tenants at the same time. Case, Ernst versus Condit Racetrack. Sublease, transaction whereby a tenant grants an interest in the lease premise less than his own or reserves to himself a reversionary interest in the term. That's a sublease. Kendall versus Ernst Pestana, Inc. San Jose Muni Airport hangar discusses the arbitrary withholding of consent by landlord of substitute assignees or sublease. The majority rule at the time, as long as there is an approval clause not requiring reasonable objection, then the landlord may object for any reason to a substitute tenant. The minority rule is that commercial leases require a commercially reasonable objection to assignment, including 1 through 7. 1, tenant mixed in multi-vendor facility, i.e. a mall. 2, legal business. 3, lawful and suitable use, production factory, office. 4, unreasonable alteration of property. 5, fiscal positioning of the assignee. 6, not to increase rent. 7, not to impose more onerous terms. Workaround also upheld as long as reasonable. Termination and recapture clause. Tenant before subletting specify subletter and terms. Landlord term and enter new lease with subletter. Terminates, that is, and enters a new lease with a subletter. Tenant not entitled to profit from termination and reletting and or term and reletting, and differences between the residential and commercial. Example, Slavin versus Rent Control Board of Brookline, 1990. Reasonableness on the part of the owner to consider suitable tenant is not required and protects the right to alienate in residential, but reasonableness is required of commercial leases, which is paramount in urban society. Argument is owner-occupied, rent control, and highest and best use allocation. So those are in the positives are owner occupation and rent control. The negative is the highest and best use allocation. Whatever. In favor in that case and negatively in that case. I'm not sure why there's plus or minus signs here. Notes: Airbnb, right to assign and sublet without the owner's consent. Subtenants. Independent local jurisdictional law. Problems: there shall be no sublease or assignment without landlord consent, and such consent shall not be unreasonably withheld. That's the language. Self-interest reasons to restraints on alienation. Example, tenant competitor Norville, Pay and Pack, Krieger. These are all cases. Want tenant to stay in negotiation at another building owned by owner. Sublease threatens neighboring evangelical lessee and abortion clinic lessee. Court held not commercially reasonable to object to sublet for personal religious belief. Subterfuge, Walgreens. Those again are cases and examples from cases of things probably not proper reasons to withhold consent. That's what that is. Rule and Dumpters case from the Restatement Second of Property, landlord-tenant, section 16.1, commentary at 125, 1977, regarding sublet to tenant 2 with consent, sublet by tenant 2 to tenant 3 without consent, and then landlord action is against tenant 2. Assignment permitted is perpetual unless reestablished after first assignment. I think what I'm trying to say there is that regardless of what your lease says, if you waive basically the requirement to withhold your reasonable consent, then when they go to lease it again, like, you cannot suddenly assert it if you didn't assert it the first time. So you need to not just acquiesce to a transfer of either in the form of either a sublease or a assignment. Change in ownership by merger and acquisition, parent subsidiary not an assignment. Stock sales dependent on terms of lease. What are those? These are all still problems. There shall be no sublease or assignment without landlord consent, and such consent shall be not unreasonably withheld. These are all, I don't know, under that section titled problems. All right, problems with that language, let's say. The tenant who defaults and landlord recourse. Possessory tenant, non-payment, holdover after term, not observed terms, and abandonment. Case, Berg v. Wiley, unlawful detainer statutes, residential 0 states, and commercial self-help is permitted in 12 states. Pros. Landlord doesn't impute justice costs to tenants. Landlord doesn't have incentive to report to credit bureau to prevent harm to other landlords. So those are pros and cons. Bargaining power is greater commercially, and residential displacement is greater psychological impact, requires immediate replacement unlike commercial use. Landlord-tenant laws don't apply to emergency shelter. Parker versus Salvation Army is a case that unlawful detainer was, I don't know, they could change locks or whatever, throw people out. Transitional living programs do submit to landlord-tenant laws. See Higdon versus Sign of Cross Housing and Cerise versus YWCA. Single room occupancy, residential hotel, and not subject to Forcible Retainer Act. Ann Arbor Tenants Union versus AAYMCA is your example of that. Forcible detainer plurality, non-traditional housing arrangements and shelters. Notes, summary proceedings, purpose and problems. Summary proceedings, ejectment overcome by self-help. Self-help available to the tenant, withhold rent for uninhabitable conditions, cannot be extrinsic. For example, outside contract terms, an average of 114 days to evict. Tenants usually have insufficient resources to retain lawyers, and underrepresented tend to default. So These are when the tenant defaults. That's all that section is about. The tenant who is and is in possession, whereas the tenant who has abandoned possession is the next section. And the case on point is Summer versus Cradell. The landlord seeking damages from a defaulting tenant is under duty to mitigate damages by making reasonable efforts to relet an apartment wrongfully vacated by the tenant. And Oregon, the landlord is under no duty to mitigate damages caused by defaulting tenant in a state called NR. The landlord cannot recover damages that the plaintiff by reasonable efforts could have avoided, and the burden of proof is of reasonable efforts on landlord, not moving party. Notes and questions. Counter argument 1, tenant's wrongdoing can't impose a duty on the landlord. Counter argument 2, restatement abandonment of property is an invitation to vandalism. And counter argument 3, avoiding interpreting reentry as unwilling acceptance of the surrender offered by tenant in default. Offer-acceptance in contract law. Surrender. Tenant's offer to end a tenancy. Acceptance by landlord extinguishes landlord of future rent. ... Landlord is not extinguished of right to back rent and past breaches. Implied express intent. Damages. Agreed rent minus the amount of loss that could have reasonably been avoided. And landlord's remedies and security devices. Build anticipatory breach remedy for present value of future agreed rent minus the reasonable rental value. So, judicious selection of tenants, security deposits. Return to term of lease less than damages. Jurors statute security deposit can be a maximum of 2 months. No comminglement. Trust can create trust escrow account. Interest on deposit. Itemized list of deduction. Penalties minus treble double. Can be double or treble. Surrounding security deposits. Alternatively, liquidated damages over and above security deposit. Bonus if returned is okay. I don't know. I do know what I think I might mean, but I'm sure it's different in every single jurisdiction. So, advance rent if apportionment for rent is allowed, and rent acceleration but can't take possession. So, what am I saying about this? I think this is, This is about security deposits, but it's in a section called Alt, liquidated damages over and above security deposits. So I don't know how to think about this advance rent and bonus stuff that we read about in Barbary. Just remember what Barbary said. What did Barbary say? Barbary wasn't talking about exceeding the security deposit. Barbary was talking about returning. You don't have to return it if it's a bonus. You don't have to return it if it's advance rent. Barbie said that too. You don't have to return it if it's meant to be like the last month's rent. But if it's a security deposit, you have to return it less damages. Done. Rent acceleration but can't take possession. Duties, rights, and remedies. That's just like last point of that section. Next section, duties, rights, and remedies, especially regarding the conditions of the lease premises. Landlord's duties, tenants, rights, and remedies. Tenant gives landlord incentive motivation to neglect maintenance because borne by tenant, not landlord, for a time, and vice versa. As is traditional rule bearing no further duty of fitness on landlord. Culture changed from time and led courts to adopt more conventional doctrine in a piecemeal manner, and propcond, property condition, I don't know what this means, can give rise to the tenant to ask landlord for decreased rent or wishes to leave, can give rise to a tort action if injury arises from defective premises, quiet enjoyment and constructive eviction. Case, Village Commons LLC versus Marion City Prosecutor's Office. The rule This is to do with constructive eviction, right? This is just read it. The rule, the contract law principle: eviction is either actual or constructive. Actual when the tenant is deprived of the occupancy of some part of the demised premise, and constructive when the lessor, without intending to oust the lessee, does an act by which the latter is deprived of the beneficial enjoyment of some part of the premises, in which case the tenant has his right of election to quit and avoid the lease and rent, or abide the wrong and seek his remedy in an action for trespass for compensatory damages. Wrongful eviction, physical interference with beneficial use, full enjoyment, common law, no landlord duty rule, shifts. That's the next point. And then short-term lease with furnishments gives implied duty of warranty of habitability to disclose latent defects not observable, apparent by reasonable inspection of. Fifth, abstain from fraudulent misrepresentation. Sixth, covenant of quiet enjoyment requires landlord provide suitable premises. Partial eviction. 7, constructive abatement of rent from the restatement. Landlord tenant for anything short of eviction in New York and some states. Actual, per the conventional rule, relieves all rent landlord may not apportion. And 8, can constructive eviction stand if neighboring tenant affected quiet enjoyment with excessive noise. The Blackett case, the JMB Properties Urban Code case, and says that the tenant move and not suffer the reduction of quiet enjoyment, his right of quiet enjoyment for 5 years, probably to succeed in a case, a constructive eviction case. Landlords should be informed of, the infringement of the quiet enjoyment of the property, real property. Cigarette smoke, yes, disturbance of quiet enjoyment. Merrill is a case about that. Upper East Lease Association, LLC. You get security measures, burglary, vandalism, violence not contained by security measures. Charlotte, Eastland Mall, LLC, and Saskia, protest, Fidelity Mutual, life insurance. These are cases where you can find more information on specific topics. And note the illegal lease. Lease is unenforceable if in violation of statutory prohibitions, not unsafe and unsanitary conditions contrary to housing code. That is beneath that you see Brown versus South Hall Realty, and no major technical violations even with notice. And I just finished the first semester outline of real property.